For motion, item number 1 and 2. Sorry, for admission.
Yesterday, Lordships has given a patient hearing, and we have comfortably met our submissions. I'm grateful for that. Yesterday, I was making reply to the submission of the Council for Respondent number 3, and I was referring to the prayer. I was responding to the prayer that the challenge was a blanket challenge. The entire enactment has been challenged when they are not agreed by all the enactments. That was the submission. So on that point, I was replying that since the entire enactment is illegal, therefore we are compelled to challenge the entire enactment. Otherwise, if we challenge piecemeal, then definitely again argument will come that, look, you have not challenged the entire enactment. So it is like that I'm putting what they are supposed to put. So the entire enactment has been challenged since the order passed by this honorable court has been violated by the impugned enactment. Now, the second point which my learned friend was submitting was the president who has filed the affidavit, sworn the affidavit, has not been authorized by the members. Since it was not so serious, so I thought it not appropriate to reply all these things. But on 23rd of May, the association has taken a resolution to approach this honorable court by challenging the enactment, and it was resolved that the president of the association should represent the association. So that decision was also taken. I'm just placing. And it was on 23rd May 2022, and the writ petition was filed on 25th May 2022. Therefore, it's not that the president has not been authorized, but he has been duly authorized by the members of the association to represent the association lordships. Now, the last reply I would like to make, lordships, on the Societies Registration Act, the Third Amendment Act of 2009, particularly Section 3A, that has been referred, that the association's registration in view of the enactment by operation of law, this association has become de-recognized. Now, in that regard, lordships, I just wanted to refer to Section 3, capital A, clause 5. May I read, lordship?
Yes.
Section 5. I think there is some typing mistake. It appears to be Section 5, although in the printing it is shown something else. A society which fails to renew its registration shall be de-registered from being a society at the expiration of 3 months from the date of expiration of the validity period.
This is section 5.
I think it's section 5 because 4 and 5. You know,
There's one,
the 4 and 5 deals with renewal.
Going by the sequence, it doesn't appear to be.
3A, 3A.
3A1, 3A1, there are two.
Yes, a printing mistake, and then the 4 and 5. I think that it should. I think it should be section 4 and 5. Otherwise, it would happen 3-2, 3A Roman 2, 3, 4 in Roman.
Where's the old act?
The whole act, no, the principal act.
3A1, 3A2, then section 4, section 5.
Yes, it appears to be. So, I think.
All that will be in the document we have, right? That is supplied. The first one.
The one you gave yesterday.
Yes, because the whole act as well as the new act.
Who is that? Ah, yeah. Old act is. Okay. Three. Not there. No. It's not yours.
Completely different.
Yeah, very different.
Your Lordship, even the subject dealt with section 3, 4, and 5 are different. Because 3 relates to the validity of the certificate issued, residence certificate.
This
4,
would be-
4 and 5 deals with renewal.
3A1, 3A2.
It should be 3A2, but it is in both. It is given 3A Roman 1.
And then section 4, section 5.
It should be right. It will make sense then in that way because the provisions also are different.
Anyway,
May I continue? So, and the proviso is there I'm just referring for our convenience as clause 5. Provided that they registered for sufficient reason to be recorded in writing may allow an application or renewal made not later than 12 months from the date of expiration of the validity period after realizing a penalty renewal fee along with the application, which shall be 4 times of the normal renewal fee. And why I'm rating this, His Lordships, clause 5, it has to be read along with proviso, and clause 5 categorically says that a society which fails to renew its registration shall be deregistered. It is used in past tense and shall be. This implies that the authority should pass an order deregistering the society should be treated as mandatory. Therefore, it is obligatory on the part of the authorities to issue a deregistration of the society. Because why I'm submitting these lordships? Proviso, there is a provision for renewal. If I commit some mischief or any default on my part, I may not be registered because the proviso says may or may not. It is not mandatory because if the society commits some mischief or some offense has been committed, then they may not be registered.
no,
Therefore-
one thing, this is clear. Yes, only thing is, after your registration in 1988, have you renewed your registration?
No, that renewal, I have not, I'm frankly considering that, unlike me, Lordships, there are many other associations, even now, who are not compliant with as per the provisions of this act. Still then, they are filing petitions after petitions and then orders have been passed, Lordships. But, Lordships, these are all technical, and I was making submission at the cost of repetition, Lordships. Even if, because of the technicalities of the petitioner number 1 goes, still petitioner number 2, 3, and 4, who are aggrieved parties, they are the petitioners. Therefore, just merely on the ground of technicalities that the association has not been renewed, the writ petition should not be dismissed. Only on the mere technicalities. In this regard, Lordships, I would like to cite only 3 rulings. One is an oral judgment, that is 1980. That is only the general principles. The other one is an order passed by the full bench of this honorable court, where my learned friend was also a party, Asangla Ayer's case under retirement. And then one Supreme Court judgment, Lordship. Firstly, I would like to refer to the order passed by this honorable court by a full bench, Lordships. It is 2021 2 GLT full bench 710. Paragraph 11 and 12. But before coming to the 2 paragraphs, Lordships, this is a case where the petitioner was allowed by the government to work till she attained 35 years by excluding the ad hoc period. An order was issued. This order has been challenged by the subordinate officers on the ground, on the ground that our promotional avenues have been adversely affected.
Just to save time, your lordship, may kindly read para 12.
Now, in that case, Lordship, a preliminary objection was raised in the writ petition. My learned friend, Mr. Takamasa, was the counsel for the petitioner, and he has raised an objection on the issue of locus standi on the same ground. But then that was rejected by the full bench. So, may I refer to paragraph 11 and 12, Lordship? Page 714. The first ground of the writ appellant before this court is about locus standi of the writ petitioners. According to the writ appellant, the writ petitioners were complete strangers to the cause they had espoused before the learned single judge. It was not a public interest litigation, and the writ petition ought to have been dismissed on the ground of maintainability itself. We are, however, not inclined to accept this argument of the writ appellant for more reasons than one. First and foremost, it is too important a matter to be discarded on a technicality of locus standi. The issue before this court is important. There must not be any confusion in any mind as to what is the real meaning of public employment in Nagaland. We have been asked to clear the ambiguities here. Considering the importance of the matter, a larger bench has been constituted to bring clarity on an important question of law, as it has wide implications in service matter in the state of Nagaland. 12. In any case, we do not think that the petitioners were complete strangers, as is being alleged. The petitioners are in the employment of Rural Development Department, and according to the writ petitioners, they were being adversely affected by the continuation of the respondent number 4 writ appellant on the post of joint director, as this affects their chances of promotion. This same argument was also raised here. Although this fact is subjected by the writ appellant on the ground that the writ petitioners were not appointed on regular capacity and they were not affected by the continuance in service of the writ appellant, yet the fact remains that they are in the same service. Even if we take the objections of the learned senior advocate for the appellant, Mr. Chaudhary, to be correct, yet the petitioners cannot be called strangers or a busybody or meddlesome interloper, as they are being made out by the writ appellant. They are members of the same service to which the writ appellant belongs. Even assuming for the sake of argument, they are not persons aggrieved and therefore not entitled to move for a writ of certiorari, yet, as we have seen, the petitioners were also impliedly praying for a writ of quo warranto, as they had questioned the continuance of the writ appellant on a public office. A writ of quo warranto is maintainable, even at the hands of a person who may, strictly speaking, not be a person aggrieved. We therefore reject the objections of the writ appellant on the locus of the petitioners. So this is also similar with that of the present case, Lordships. Now, the second judgment, Lordships, 2015 for SCC, page 30, paragraph 3 and 8. This is a case of selection of Anganwadi workers. One of the candidates who was not belonging to that center has been selected and recommended. That was challenged by the person whose candidature has been denied. Writ petition has been dismissed. Appellate court has reversed that and it came to the ethics court. Kindly come to paragraph 3 for the facts, Lordship. Just a short paragraph. The moot questions to be answered in this appeal is whether the division bench should have allowed the writ appeal only on technicalities and on the basis of certain orders passed earlier, when on facts there was no ambiguity that respondent number 1 was not a resident of the center concerned and hence lacked the basic eligibility for engagement as Anganwadi worker for the center. And then kindly come to paragraph 8. This is the finding. And just above paragraph 8, fourth line, starting from the right, the division bench further erred in ignoring the case of the official respondents that respondent 1 lacked the eligibility qualification for selection and engagement because she was not the resident of the center in question. Paragraph 8. In the aforesaid facts and circumstances, we have no option but to accept the contention advanced on behalf of the appellant that the order under appeal has been passed without looking into the relevant facts and ignoring the well-settled principle in respect of exercise of writ jurisdiction under Article 226 of the Constitution of India, that such jurisdiction should not be exercised on mere technicalities, especially if the result of such exercise will amount to perpetuation of illegalities. In the present case, the appointment of the respondent number 1 made pursuant to the order under appeal is clearly illegal, as she did not have the eligibility qualifications. This is also the stand of the official respondents, even in the counter affidavit filed before this court. So some technical points have been raised, but considering the magnitude of the illegality committed by the respondent authorities and committed by the court also, the division bench of the High Court, The ethics court said that, look, when there is clear illegality, then on mere technicalities, the petition cannot be decided. Therefore, Lordship, even in our case, considering the amendment, entire amendment, which has been done in violation of the order passed by this Honorable Court and ignoring all the principles of law. Therefore, this is not a case to be rejected merely on the issue of technicalities, merely on the issue of the maintainability. Just as a general conception of the law on the technicalities, I will just refer from one of the judgments passed by the Apex Court, which is reported in EIR 1981, Supreme Court 298. And paragraph is 63. I believe the copies are not before your lordships, but it is a short paragraph. Let me just read out. This is only the principle how the court should examine when the issue of maintainability or technicality has been raised on the issue of locus standi and on the ground of petitioners. One is not a recognized association, so it should be rejected. But then other petitioners are there, so that we're allowed to maintain. Paragraph 63. A technical point is taken in the counter affidavit that the first petitioner is an unrecognized association and that, therefore, the petition to that extent is not sustainable. It has to be overruled, whether the petitioners belong to a recognized union or not. The fact remains that a large body of persons with a common grievance exists, and they have approached this court under Article 32. Our current procedural jurisprudence is not of individualistic Anglo-Indian mold. It is broad-based and people-oriented and envision access to justice through class actions, public interest litigations, and representative proceedings. Indeed, little Indians in large numbers seeking remedies in courts through collective proceedings instead of being driven to an expensive plurality of litigation is an affirmation of participative justice in our democracy. We have no hesitation in holding that the narrow concept of cause of action and persons aggrieved and individual litigation is becoming obsolete in some jurisdictions. It must fairly be stated that the learned Attorney General has taken no objection to a non-recognized association maintaining the writ petitions. So these are the concepts, lordships, where just under mere technicalities, a petition cannot be decided. More particularly, when there are illegalities on the action of the respondents. So, my submissions to the argument advanced by the respondents on the ground of maintainability is, on the ground of objection on maintainability, goes by operation of law. Like that the registration goes by operation of law, which my learned friend has submitted. So the technical objection also goes by operation of law. Therefore, it is a fit case, lordship, where it can be decided by entering into the merits, lordship. And if it is decided only under mere technicalities, only under ground of maintainability, that too confining to petitioner number one, injustice will be done to the petitioners. And besides the petitioners, even assuming that the writ petition is dismissed on the ground of maintainability with regard to the petitioner number one, there are still petitioner number 2, 3, and 4 who are aggrieved persons. The judgments which I have referred to, Lordships, these judgments will clearly govern how a person is affected in the promotional avenues. Because objection in those cases were raised that, look, this is only a mere chance for promotion. Your rights have not been affected. That was the objection raised. But then look, they are in the same department. They are working in the department. Definitely their chances of promotion will be affected. Therefore, the writ has been entertained, Lordship. And that argument, on the ground of preliminary objection, on the ground of locus standi, on the ground of aggrieved party, has been ignored by this honorable court, Lordships. Therefore, my respectful submission is this case should be decided on taking into consideration of the merit. Yesterday, during the initial stage, I have been allowed to make submissions on the merits of the case. Since we are examining a matter relating to the legislation, little bit of patience is also required. So far as I am concerned, my patience is very limited. So I will try to take the shortest time as far as possible, and by referring to the relevant provisions only, and as far as possible, I will try to avoid the irrelevant grounds. So, Lordships, may I submit on the merit?
You want to reply on this? Yes. Okay, let them reply. After that, we will enter into close.
May I, Your Lordship? Your Lordship, yesterday, the Learned Senior Counsel has made some very interesting submission to which I feel I need to reply, but be brief, Your Lordship. But at the outset, yesterday, Your Lordship has asked me to find some citation on the phrase operation of law, Your Lordship. Last evening, I couldn't, but Your Lordship, if I may be allowed to, to this thing, provided I get it to place before Your Lordship tomorrow, Your Lordship. Because if I'm sure I will be replying only tomorrow, Your Lordship, to the merit. Now coming to the submission, coming to the submission which the Learned Senior Counsel has made.
Hopefully, we can conclude this week.
By tomorrow.
By tomorrow.
And he has already made his stated he will not take much time, he will be short. If then we can conclude tomorrow, Your Lordship. I'll be brief one. I'll confine to my reply only. Now, the first submission which the Learned Senior Counsel made yesterday was that legislation made by the Parliament and the State Legislative Assembly are different than the rules made by the governor in excess of power under Article 187(3), or for that matter, proviso to 309, Your Lordship. Now, in my respectful submission, that is totally I'll just say wrong submission, Your Lordship, because both under Article 187(3) and proviso to 309, Your Lordship, the power exercised by the governor is legislative in character. I will just place the citation, Your Lordship. 1980, Supply SEC. (524). 1980, Supply SEC 524. Para 44. This is B.S. Yadav's case, Your Lordship. This is by a constitutional bench. May I read out? Just the relevant portion, 9th line from the top. The proviso to Article 309, Lordship has got it? The proviso to Article 309 provides, insofar as material, that until the state legislature passes a law on the particular subject, it shall be competent to the governor of the state to make rules regulating the recruitment and the condition of the judicial officer of the state. The governor thus steps in when the legislature does not act. The power exercised by the governor under the proviso is thus a power which the legislature is competent to exercise but has in fact not exercised. It partakes the character of the legislative, not executive power. It is a legislative power, Your Lordship. So, Your Lordship, there is no distinction. Legislation passed by the parliament or, for that matter, the state legislative assembly, and the rules framed by the governor in exercise of power under 187.3 or, for that matter, proviso to 309 are same. Governor exercises legislative power, Your Lordship. So the submission advanced by the learned senior counsel that they exercise different power is totally wrong. Now, Your Lordship, the learned senior counsel has also tried to differentiate between the trade union and the petitions association, Your Lordship. But the issue involved in this is not as regards the nature, the purpose for which the association or the union is formed, but the issue involved is the validity of the registration certificate issued by a competent authority, be it the trade union or service association, Your Lordship. So just it has got nothing to do with the nature or the purpose for which the union has been formed, Your Lordship. Now, third, Your Lordship, yesterday also, the learned senior counsel, he has made the submission. This morning also, he has reiterated the same, that no order has been issued deregistering the petitions association, Your Lordship. Here, and in this connection, Your Lordship asked me to bring some citation as regards the operation of law, Your Lordship. But in my respectful submission, Your Lordship, the issue involved is not much on the interpretation of the phrase operation by operation of law, Your Lordship, but on the interpretation of the statute, Your Lordship. Now, and the golden rule of interpretation is the whole statute, Your Lordship, is to be read as a whole, Your Lordship, not in isolation. Here, Section 5, Learned Senior Counsel, he has referred to Section 5 of the Society Registration Act, Your Lordship, but the Act has to be read as a whole, not in isolation, Your Lordship. And in that, for that, in support, I would like to refer to 2014, 3 SCC, page 92. This, Your Lordship, is also by a constitutional bench. And paragraph also 44. Para 44. May I read out? No word in a statute has to be construed as surplusage. No word can be rendered ineffective or purposeless. Courts are required to carry out the legislative intent fully and completely. While construing a provision, full effect is to be given to the language used therein, giving reference to the context and other provisions of the statute. Giving reference to the context and other provisions of the statute. By construction, a provision should not be reduced to a dead letter or useless lumber, Your Worship. So other provision of the statute, that has to be also taken into consideration while interpreting, Your Worship. Now, therefore, Your Worship, in my respectful submission, Section 5 cannot be read in isolation. And moreover, as I've said, Section 4 and 5 deals with renewal, Your Worship. Now, if that in Section 5, if we confine to Section 5, reading Section 5 as in this isolation, Your Worship, unless an order is issued deregistering the society, Your Worship, then the society is still alive. But Section 3.1, Section 3A1, both one, Your Worship, that provides the validity period. Once the validity period is over, it expired. Now, by their own admission, the petitioner is more is not a number of days, months, year, but more than a decade. The petitioners association has not even applied for renewal, Your Worship. It is already dead, Your Worship. But if we read only Section 5 in isolation, that it will mean that the association is still alive. But it's not so. So by operation, by virtue of Section 3A1, by operation of that Section 3A1, Your Worship, the society is no more, Your Worship. So in my respectful submission, Your Worship, Section 5 cannot be read in isolation. The whole provision, the whole statute has to be read as a whole, Your Worship. And that is the golden rule of interpretation of statutes, Your Worship. Now, Your Worship, the fourth submission advance was twin submission, that the rules were not amended as per law, and also in circumvention of the judgment passed by this Honorable Court, in violation of the order passed by this Honorable Court, Your Worship. For a moment, may I refer to the judgment, which is at page 48 of the writ petition, Your Worship. Page 48, Your Worship. Lordship has got it. Now, relevant para 27, page 69. To save time, I'll just refer to the relevant paragraph. Lordship has got it, para 27. Now, 8 line from the top. Be that as it may, the last word, the 8 line, Lordship has got it. Be that as it may, as already noticed here and above. Lordship has got it. The residuary powers conferred upon the Speaker by the rules of 1999 cannot be construed as the power to amend the principal rules, which otherwise has been framed in exercise of power conferred by Clause 3 of Article 187 of the Constitution of India. Now, para 32, Your Lordship. Which is at page 73. Seventh line from top. As for Rule 22 of the Rules of 1999 as amended, it has already been held here and above that the residual power given to the Speaker does not include the power to amend the rules, and therefore invoking the said rule to restructure the cadre of the post under the Assembly Secretary Service cannot be sustained. What has happened, Your Lordship? The restructuring was done, rule was framed in excess of Rule 22 of the Secretary Service Rule, which is residual power. does not give the speaker the power to amend the rules. If rules are to be amended, it has to be as per Article 187(3). So that is what the course. Now, next, para 35. That is why, Your Lordship, this honorable court has interfered with the notification, the amendment made. Para 35, page 76, Your Lordship has got it. 6 lines from the bottom. So it was interfered, amendment was interfered. However, Lordship has got it. However, the same shall not debar the respondent authorities concerned from considering the restructuring of various posts under the Assembly Secretariat, which should otherwise only be done in accordance with the relevant provision of law and by taking into consideration the rights and interests of all the stakeholders. Now, even the learned single judge, in fact, he has also here, there were some discrepancies where they so felt the necessity that restructure has to be done. And even yesterday, the Learned Senior Council has made a submission that cadre reviews were also constituted from time to time to restructure. It is not overnight or not an afterthought, Your Lordship. So, after going to the rules, this court has also given liberty to the respondent. Okay, to restructure you can, but you do it as per the law, and taking into consideration the interests of all the stakeholders. Now, what is the grievance of the petitioner? Grievance of the petitioner, Your Lordship, if Your Lordship may kindly recollect the submission made by the Learned Senior Council. Cadre review committee was constituted. No report was submitted. Without any report being submitted by the cadre review committee, the rules were amended. That was not the direction passed by this honorable court. You do it as per the law. And what does Article 187(3) says? Under Article 187(3), for the governor to amend the rules or to frame rules, it is not necessary for the governor to wait for or to get a report of the cadre review committee and then only to amend the law. No. The learned single judge has interfered with the earlier notification because that amendment was done in excess of Rule 22. That was not as per the rule. Your Rule 22 of the Secretary Service Rule provides only to relax the rules, not to amend the rules. So if you are to amend the rules, you amend under Article 187(3). Accordingly, in Para 10 of my affidavit, accordingly, this present amendment was done in excess of power under 187(3). Para 10 of my affidavit, which the Learned Senior Council has read out yesterday, Your Worship. Now, therefore, what amendment has been done, that was done after taking into consideration the interests of all the stakeholders. Even the private respondent here is one of the stakeholders. Supposing I don't take into consideration his interests, tomorrow he will come, no, my interest has not been taken into consideration, which is in violation of this honorable court's order. It is not only the members of this association, or for that matter, petitioner number 2, 3, and 4, they want to protect their interests. But as an employer, and as directed by this honorable court, I have to ensure that the interests of all the stakeholders are taken into consideration while amending the rules. Private respondent is not a stranger. Court has directed me. I am to take his interests also into consideration. So rules were amended, and that is in consonance with, as per the terms of the direction passed by this honorable court. There's nothing wrong in that.
That will vary on merits.
Lordship. Now, so where is the issue of this circumventing or violating the court's order? And the main grievance, Lordship, Lord, I have no issue if Lordship hears in the merit, but the main grievance of the petitioner, as I said, Your Lordship, yesterday, at the cost of repetition, the challenge in this is not a policy decision, not an order passed under Article 162, but a piece of legislation where the petitioner, before exercising the power under Article 226, this Honorable Court has to be satisfied that petitioner's fundamental right is infringed, that he is an aggrieved person. And this is the only ground taken by the petitioner that how he is aggrieved, because it is not done as per the law. Which law? And the petitioner has also questioned how signatures were obtained. The principle of law laid down by the Honorable Supreme Court is very clear. This is not like a contract, award of contract where this court can access the judicial power and go into the decision-making process. No. Only on two grounds it can be challenged. How the file was processed, how it was overnight, the parliament can pass a bill, pass an act. The court cannot go into the decision-making process, how overnight, midnight you pass an act, GST bill. Whether legislative competence can be questioned, violation of fundamental rights can be questioned, but not the decision-making process. Going into the file noting, referring to the file, those are decision makers, and this is not an award of contract, Your Lordship. So why I am saying this, Your Lordship? Your Lordship is right. These are issues which can be considered into merit. I have no objection, Your Lordship. But the grievance, how are they aggrieved? That petitioner needs to satisfy this Honorable Court first before examining the constitutionality of a piece of legislation, Your Lordship. Lastly, Your Lordship, Learned Senior Counsel has also made a submission that citation, the decision which I referred to, they are not relevant because the facts are different. In all the cases, Your Lordship, the facts and circumstances are different, Your Lordship. But what is the principle laid down? That needs to be considered, Your Lordship. I conclude that's much obliged.
Lordship, just one point of clarification. I will not take much time. I'll simply take 1-2 minutes. Learned Counsel for the petitioner has raised the issue of that technicality cannot be a ground. My Lord, registration and non-registration of a society is a question of law, because right and liabilities flows from a registered document or non-registered document. So it is not a technicality, one. Secondly, Lordship, my learned friend has referred to a judgment, the last judgment, EIR, where the concept of Little Indians, in fact, this is a concept coined by Justice Pakwati with regard to PIL litigations, starting from Sharla Parsi case onwards. Now, my Lord, this Little Indian technicality in PIL matters, my Lord, non-registration, this Honorable Court can waived non-registration of an association coming for this court on the concept of Little Indian because of their poverty, illiteracy, ignorance. That's how this concept was formulated. However, my Lord, the present case, it is not a PIL. And, my Lord, the petitioners, all qualified associations, additional secretary, joint secretaries, members of an association of a secretariat cannot be termed illiterate, ignorant, or the word concept Little Indian, it does not come within that purview. So, my Lord, technicality. My lord, plea for technicality, that to waive defeat justice on the ground of technicality will not be applicable in the present case, especially when, Lordship, the other day also I was mentioning, the conduct of the petitioner is without clean hands. Lordship, and on the question of circumventing the judgment of the Honorable of the single bench judgment, in my respectful submission, that is part of the merit. So, my lord, and my lord, the other day, my learned friend was referring to Article 13. My lord, Article 13, with due respect, is talk about pre-independent laws. As in when if we go into the merit of the case, that time we will reply on that point, Lordship. Obliged, Lordship.
Yes.
Before I start my submission, Lordship, the judgment which I have referred to, that 1981,
Oh,
that is being placed, paragraph 63. APSK Sang Railway versus Union of India. This is not a PIL. And my learned friend's submission is, this is a PIL, but it is not so. It is not. May I proceed, Lordship? The petitioners are aggrieved by the notification dated 18 May 2022. And by this notification, the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rules 1999 has been amended under the name and style of Third Amendment Rules, Third Amendment of 2022. As many as 7 changes have been made by this notification in the rules. So what are those 7 changes they have made and how they have made? May I just refer to the service rule, existing service rule, that is starting from page 17. And the new amended rules by notification of 18th May 2022, it starts from page 45. So the existing service rule has been folded, and just by leaving the folded ones, then page 45 is there. That is the amended rules. We are required to refer from old rules to new rules, what changes have been made. So some inconvenience may also be there, but it will be necessary to refer to put. Firstly, Lordships, the first changes which they have made is under Rule 6. Lordships will find at page 19. Page 19, Rule 6. There are 2 paragraphs under Rule 6, the function of the port. In the first paragraph, there was no changes, but in the second paragraph, that is a proviso, last 2 lines, subordinate and grade 4 staff for a period not exceeding 3 months. 3 months have been changed to 6 months by the Third Amendment. So that is the changes they have made. That is number 1. the amendment, what were made in the rules. So it is talking about grade 4 staff. So amendment has been done. And submission was also made at the time of maintainability that grade 4 employees, they are not affected by the amendment, but all these are there. It has been increased to 6 years. That is first change. Second change is under Rule 9, the method of recruitment. Lordships will find there are 3 recruitment under the existing old rule, I should say, and they have inserted 2 things here. They have added one clause, that is clause D. Lordship will find it page 45. Clause D was inserted by the new amendment by short-term contractual appointment. That was added under Rule 9. So the word used here in the amendment is engagement. Not appointment, but engagement, by short-term contractual engagement. So a person can be engaged, not appointed. So that was added. So we are saying that, look, you are making appointments on contract contrary to the provisions of the Nagaland Retirement from Public Employment Act. All this, we are raising that. And the third changes has been made under Rule 10, that is page 19, same page, streamlining of the existing gather. Here, this A and B, Lordships will find, the earlier litigation was when this rule was in existence, the earlier litigation of 323 of 2021, that is decided on the basis of this existing rule. Thereafter, they have amended the rule up to the judgment. Here, there are 2 clauses, clause A and B. And relevant portion, Lordship will find here, and under clause B, there shall be no intertransferability between the various schedules in the event of similar skills between the gatherers. So earlier, out of the 8 schedules, there can be no intertransferability between the schedules. That was the rule. And these 2 clauses A and B has been replaced up to the judgment. And under Rule 10, page 46, the new changes Lordship will find on the top, the 2 clauses, clause A and B. There shall be no page 46, Lordships. There shall be no intertransferability between the gatherers, schedules, up to the rank of joint secretary. Up to the rank of joint secretary, this has been added. And the clause B, there shall be no distinction of gatherers above the level of joint secretary in the assignment of duties, distribution of works, and for all other service matters. So these 2 has been inserted. Now, under the old rules, transferability was banned. But here they have made a distinction. Below joint secretary, transferability is not possible, but above the joint secretary, transferability of the gatherers is made possible. This Lordship will find, for a short analysis, kindly come to the old rule under schedules, page 28. I am trying to show what are the schedules, what are the posts, and the different schedules. Page 28. This is Schedule A. In other words, this is the general gather. Third Schedule A. Then column 1, secretary. I will just show only the posts which are there under the schedules. Later on, I will come back. Under these schedules, there are 9 categories of posts. This is the only schedule where a person can go up to the post of secretary. And kindly come to page 31. This is third schedule P. The topmost post here is senior special grade stenographer. And there has been some changes in this by a notification of the government. A post of OST to speaker has been upgraded, equivalent to the rank of additional secretary. And this post creation is only for the stenos. It is categorically mentioned in the post creation order that that post will be only for the stenos, not for others. So I will refer to the post creation. And this is, besides third schedule A, this is one schedule where there is a post, equivalent post above joint secretary. Otherwise, other schedules, there is no equivalent post. So can we come to the page 33? The same gather. This is the eligibility criteria. Graduate having diploma in stenography. So educational qualification is also prescribed. A person who is having the stenography, only then such persons can be appointed as promoted to the post of OST to the speaker. So qualification is prescribed there. But by making the interchangeability, without having the requisite qualification as provided under the rules, because they have not changed this qualification, I have been made to transfer to another post. And next schedule is schedule D. Schedule C, sorry, page 34. The topmost post is senior librarian. There is no equivalent post above joint secretary, and that is schedule also. Even if permit under the rules, there is no officer. Third schedule D, page 35. Except the private respondent number 3. The topmost post is the transport officer under this schedule D. And the respondent number 3 is holding a post in the rank of additional secretary, which has been upgraded personal to the incumbent. To the joint secretary also, personal to the incumbent. And the additional secretary, personal to the incumbent. So she is the only person and the post holding in the rank of additional secretary under third schedule T. That too, personal to the incumbent. And till today, the private respondent number 3 has not been engaged. She has not been brought into gather. Interchangeability has been made permissible by the new amendment, but one has to be brought to the grade, to the gather. Then only he become eligible to hold the post. Can we come to page 36, page 37, schedule E. Here also, there is no post equivalent to additional secretary, not above the joint secretary. And next schedule is,
Oh, you mean to say that computer application supervisor is equivalent to joint secretary?
no, even below that. I'm trying to show from the schedules what are the posts which are equivalent in the rank of additional secretary, so that this post can be intertransferable. That is why we have taken a point tailor-made. by targeting some individuals, they have tailored the rules in such a way that it will suit them so as to favor some individuals. That is what we have taken in the pleadings, Lordships. Next, page 39, third schedule F. This is the diverse cadre. There is no post even equivalent to the joint secretary. And then kindly come to page 41. No post in the rank of additional secretary. The topmost post, number 1 post is record assistant, class 3 non-gazetted. And then schedule H. Topmost post is PS2, Honorable Speaker, HODs, HDS, and LO. These are tenure posts which can be appointed by the Speaker. And there is no post even under Schedule H, which is equivalent to the additional secretary. Now, next amendment is Rule 12, page 20. This is the 4th changes we have made. In the amended rules, Lordships will find it page 46. Here, under Rule 12, appointing authority, clause 1, the secretary and additional secretary shall be appointed by the governor in consultation with the Speaker. Here, they have added one thing, that is, in consultation with the Chief Minister. That has been added. Earlier, it was only the Speaker to be consulted, but now Chief Minister has been inserted. So this is one of the changes they have made. And next amendment which they have made is under Rule 15, clause 4. That is in the next page, page 21. Roman 4. ACR of preceding 5 years. There is some changes to the rating only. Lordships will find
Para 4.
yes, at page 46.
Para 4.
This is just pertaining to the grades, rating in the ACRs.
What is para 4?
Para 4 is
Para 4, serial number 4.
ACR.
ACR of preceding 5 years.
Okay.
Under Rule 15, paragraph 4, serial number 4 is modified as follows. Annual performance appraisal assessment report of the preceding 5 years, giving the average benchmark requirement of very good rating or numerical rating of 5, 6. How marks is to be given? Only that much. So we are not very much concerned on this, Lordships. And then there is a hidden agenda here also, even here. Because the person who has filed a writ petition earlier, you don't want him to come up so that only when some changes is made in the ACRs, ABAR, then he can be given lower grade so that he cannot be promoted. Very wisely done.
But you said
I appreciate their ingenuity.
you're not concerned. Yes.
Now, next changes that's been made in the schedules. In the third schedule A,
Rule 15 also is there. I think. No, 15 is already.
15 is
Yes,
already,
yes.
I have referred to Lordship.
Third
It-
schedule.
It's here, the next one. And then the next one is in the
Third
schedule.
schedule.
Under serial number 7, page 46. In third schedule A, serial number 1, column number 6 of the following shall replace the existing entry. And then Lordships will find at page 28, the third schedule A. Third schedule A, serial number 1 is on the extreme left. That is the secretary, the post of secretary. And column number 6, Lordship, first column number 6, qualifications for direct recruitment. This entire qualification has been replaced and contract appointment is added here.
1 minute. One.
The amended rule is at page 46. Deputation. Page 46. Deputation. I'm not relying on the other entries, but contract. Below that contract, this is in addition. A superannuated officer who is otherwise eligible to be appointed on deputation, not exceeding the age of 65 years. So
That provision is not there.
this provision is not there in the old rules. So this has been added and up to 65 years. Because at this point of time, one Dr. Anthony, who was brought into petition, he was working and he retired in 2020 by superannuation. Thereafter, he was appointed. After appointment, he was allowed to discharge the duties and responsibilities and functions of the head of the department. He was issuing orders like any other HODs because he was met the HODs. So my question is it not contradictory to the Nagaland Retirement from Public Employment Act, which is made applicable to the Nagaland Legislative Assembly service also? So what they cannot do directly, they are doing it indirectly. Yes, no doubt, if his service is so indispensable, government can appoint him as advisor or a consultant and get his services. But he was met the HOD and entire powers and responsibilities of the secretary, which was earlier discharged by the secretary, has been discharged by the commissioner secretary. So de facto secretary also. So this has been inserted in the third schedule A. Now, the last changes which they have made is Lordship will find at page 47, and the old rule is at page 28, the same. They have added one word that is or equivalent has been added here. By serial number 7, grade from which promotion to be made. by promotion from additional secretary, Nagaland Legislative Assembly with minimum 2 years continuous service in the grade or as deemed fit. In the grade is mentioned, or equivalent has been added by the new amendment. Equivalent. So what are the equivalent posts? As I was referring to the different schedules, there are 3 posts which are above Joint Secretary, 3 schedules in the rules. Schedule A, that is the general cadre, and another schedule is the transport wing, where the topmost post was the transport officer, and the other cadre is steno cadre, schedule, I think, D. There, a post has been created. No, schedule B is the steno, and schedule D is transport. So only 3 schedules. Schedule A, schedule B, that is the OSD to speaker, and schedule D, that is the transport wing. Only in these 3 schedules, there are posts which is above the Joint Secretary. And out of that, A is general cadre. Let us examine the 2 posts. What are the 2 other posts? Can we come to the last page of the writ petition, page 105. This is the creation of post of officer on special duty. On the recommendation of the post creation board, this has been created. And on the extreme right column, Lordship will find the remarks. Created only for stenos. Officer on special duty, 1 post, scale is given, and created only for stenos. So this post has been created only for the stenos. But going by the enactment, they have made interchangeability between the schedules above the Joint Secretary. So, since this post is created only for the stenos, we cannot go. But by application of the rules, it may be possible for her to come to our cadre. Although this post is only for the stenos, it was made possible by the new amendment to come. But we cannot go. Then 1 post will be lying vacant, the post of OST.
1 minute. Secretary. 37,600.
To make it more clear, Lordship, I'm troubling your Lordships. Kindly come to affidavit in reply against the affidavit in opposition of respondent number 3. To clarify this point more.
Affidavit.
Affidavit in reply on behalf of the petitioners against the affidavit in opposition of respondent number 3. Has your Lordship got it? Yes. This is by the creation and operation board of the Assembly Secretariat.
Which page? Which page?
Page 121, sorry, Annexure G. Page 121, 25th October 2017. To save time, Lordship, kindly come towards the bottom, just above the box, serial number 2. Having elaborately deliberated on the recommendation item-wise, the board has approved for creation, upgradation as under, and then we are concerned with serial number 1. name of the post, officer on special duty, in the rank of additional secretary. In the rank, equivalent rank was met by the post creation. One post to be created to be filled up by the senior most stenographers. This post has to be created to be filled up by the senior most stenographers, no others. And the qualifications for recruitment to the post of stenography is a must to hold this post. The petitioners are not stenos. Petitioners do not possess requisite qualification. They are not eligible to hold the post. Then, how interchangeable can be done? So role is compelling us to hold a post for which we do not possess the requisite qualification. And this post has been created only for the post of steno. That is the reason why we are submitting that this is unreasonable, violative of fundamental rights. Qualification has not been amended for the post of steno, lordships. So, page 20.
Mr. CT,
Lordship.
just one clarification.
Lordship.
See, in this page 121, officer on special duty in the rank of additional secretary,
Yes,
correct?
yes.
Now, whether this officer on special duty is eligible for promotion to the post of secretary?
No,
No.
no.
And your case is that under the unamended rules, it is only the general cadre officer who were eligible to be promoted to the post of secretary.
Yes.
Is it not that?
Yes, yes. That is my summation. And kindly come to page 20 of the writ petition under rules. Rule 11. This has not been
But,
touched.
one thing, page 105 of your writ petition.
Yes.
This officer on special duty,
Yes.
it's in the pay scale of secretary.
Yes. Equivalence of post do not confer a right to hold a post. It was made equivalent, but whether she belonged to the cadre. One has to be in that grade so as to promote.
One has to be in that cadre means the general cadre
Yes,
for promotion to the post of
yes,
secretary.
yes,
And the other cadres, they are not eligible.
yes. And if you want to make it eligible, then you have to make suitable amendments. That is what I'm submitting, Lordship. Kindly come to page 20,
And,
roll,
and just
roll
to
11,
cut it short, just to make us understand,
Lordship.
just to make us understand, by the amended rules, who were brought in? By the amended rules.
Yes.
The latest notification.
I must submit that nobody has been brought.
Nobody has been brought.
Yes, because nobody is eligible to hold the post.
Who is holding the post now?
No one.
None.
No. Private respondent number 3. These issues have been decided in the earlier litigation. At present, the respondent number 3 is holding the post of secretary,
Holding the charge.
holding the charge. And next petition is
On the
about
basis of
the
promotion
current
personal
charge.
to her.
Current charge, yes,
On the basis of promotion personal to her.
yes, correct. And can we come to page 20, how qualification for recruitment and promotions are being done? This role has not been changed and this is existing.
Page 20 of your,
Writ petition, Lordships. Rule 11. That's your Lordship's got it?
yes.
The qualification for recruitment and promotion to any post or class of post shall be such as specified in the third schedule. Provided further that personal staff of Speaker, Deputy Speaker, and leader of opposition, as the case may be, shall be made from amongst the officials of the Assembly Secretary belonging to the respective categories from time to time. That may not be very relevant, but the first part is relevant. The qualifications for recruitment and promotion to any post or class of post shall be such as specified in the third schedule. So it has to be provided in the third schedule how it has to be promoted, and the qualification has to be there. And for holding the post of stenos, lordships, as I have been referring to the schedule P, page 31. If we look at the qualification at page 33, because it is a continuation of schedule B, how they are recruited. Serial number 7, page 33. Direct recruitment, graduate having diploma in stenography with so-and-so words are there. And the topmost post in this
Maybe 6 would be.
schedule is
6 would be more relevant. 6. Stenographer grade 2. This is also by direct recruitment, 25%. Anyway.
But in any case, qualification is prescribed under column 6.
Yes.
Promotion can be,
Yes.
without properly amending the rule, they have made it possible to interchangeability. Therefore, in the earlier litigation, 4 petitioners have challenged because a person who is holding an ex-cadre post has been brought and occupied the post of additional secretary. That was challenged. And in that petition also, the respondents, they have raised the issue of maintainability under local standard and agreed person. All these points have been raised, but this honorable court has not entertained all these objections. And it was decided on merit. I will refer to the judgments, lordships. I will refer only to the relevant paragraphs. Since an officer who is not in the cadre has been brought to the general cadre to schedule 1, third schedule A, and occupied the post of additional secretary, that is how the promotional avenues of the petitioners have been affected. Therefore, the writ petition has been filed, and by a judgment and order dated 12/5/2022, this honorable court has decided that issue. But here, lordships are hearing this by the division bench in view of the rules that when amendments are there, then it can be heard by a division bench. So in exercise of writ jurisdiction, the lordships are hearing this as a writ. Now,
So, Mr. Siti,
lordships,
just one clarification
yes,
by way of information. This, your page 28.
28,
I'm a little confused on this issue, so I just want to go back to this. Page 28. Page 28, correct?
Page
Your-
20.
Your writ petition.
20.
28.
Yes, lordship,
So this third schedule A.
yes,
So it is only the officials in the third schedule A
yes,
who comes under the general cadre.
yes,
And these are the only officials who are eligible for promotion to the post of secretary,
yes,
as per the unamended rules.
yes,
Okay. And not from the other schedule B, C.
yes. And Rule 11 has not been touched. It is still existing. The qualification and for promotion. Rule 11 may not be ignored. It is not Dutch.
Rule 11 of the unamended rules.
Yes, that is still intact. That has not been touched by the new amendment. It is there. Therefore, how it should be appointed, how it should be promoted, it is laid down under Rule 11 covers that. If I'm clear, lordships, may I take to the judgment? The relevant portion of the judgments only. Judgment, it starts from page 48, but I will take your lordship's attention only to the relevant portions. With regard to the maintenance, all this have been discussed. I'm not referring to this. Page 64, I'm reading from paragraph 22. This is relevant. At some point of time, I may also have some pause, and then I would pray before the noble court that the lordship may bear with me. Paragraph 22. May I read, lordships? Coming to the merit of the case, as may be noticed, the issue to be decided is as to whether the restructuring of the gather and the encadrement of the post of additional secretary transport in the third schedule A from third schedule D in the manner it was done through office memorandum dated 1/11/2021 is sustainable in law. Further, whether the respondent number 3 could have been regularized to the sanctioned post of additional secretary pursuant to the restructuring of the gather via the MBO notification. It may be seen that under the rules of 1966, there was no post of assistant transport officer and that the post of ATO, ACO, and ARO were created with concurrence of the Finance Department on 10/7/1995, and the posts were classified as Class 2 cadet and carrying identical pay scale and status. Accordingly, an advertisement was issued on 20/12/1995 for filling of the post of ARO and ATO, Assistant Research Officer and Assistant Transport Officer. The respondent number 3 responded to the advertisement and she was accordingly appointed to the post of ATO by notification dated 1/10/1996 in exercise of powers conferred upon the Speaker of the Assembly by Rule 9, Clause 2 of the Rules of 1966. The rules of 1966 came to be repealed by the rules of 1999, which came into force with effect from 17/11/1999. The post of ARO and ATO came to be mentioned for the first time in the rules against the third schedule. It may be seen that the post of ACO and ARO have been mentioned together in the third schedule, while the post of ATO has been placed separately. In other words, the post of ACO and the ARO, this is ARO, lordships, admittedly had been placed in the general line wherein the incumbents holding the said posts can rise to the rank of secretary by promotion. Insofar as the post of ATO is concerned, there appears to be no further scope for promotion beyond ATO. And then I'm skipping paragraph 23. Can we come to paragraph 24? What can be seen from the above abstract is that, as per Rule 10, Clause P, irrespective of the relativity of the post, intertransfer between the various schedules in the event of similar scale between the cadres is not permissible. With the insertion of this provision, the incumbents in the post of GTO and ATO, or for that matter, transport officer, having placed in the third schedule D, cannot be considered for transfer and promotion against any of the posts mentioned in the other schedules, and particularly against third schedule A for the purpose of present case. What was relatively not clear and not certain in the principal rules of 1999 and the first amendment in the year 2005 have been made clear by the second amendment made in 2012. The respondent number 3, as pointed out by the petitioner, has been enjoying promotions from the post originally held by her as ATO. After the same was upgraded to the post of TO, and thereafter with similar upgradation to senior TO, joint secretary, and additional secretary. All were made personal to the incumbent. I am not referring to the orders to save time. Such upgradation and promotion made in favor of the respondent number 3 has, however, been made personal to her, and the post is to be automatically reverted back to the original post once she vacates the said post. According to the petitioners, that is why they have not challenged the promotions of the respondent number 3, as her promotion was personal to her. What has caused the dispute now is the issuance of the imbued office memorandum and the imbued notification, regularizing the respondent number 3 as additional secretary against the sanctioned post of additional secretary. Now, this for a post, short post, this honorable court said that it is not permissible under Rule 10p, because under Rule 10p, no transferability was allowed, but it was brought in. And this honorable court has arrived to a finding, categorical finding on this point, but the notification has made it possible. This honorable court said that it is not possible. They have not challenged the judgment. But by amending the rules, it was made possible. That is the reason why we are taking, in order to circumvent the order passed by this honorable court, this rule, this amendment has been issued. So here the question is whether the order passed by this honorable court should remain or the amendment should be remain. Because one says, don't do it, it's not possible. They said it's possible. And this honorable court has in categorical terms said that it has to be done in accordance with, only in accordance with law and taking into consideration of all the stakeholders. So that way our rights have been violated, lordships. And if any law is violated by the lawmaking authority, definitely this honorable court can interfere. Let me continue, lordships. Paragraph 25. The rules of 1999 was framed in exercise of powers conferred by Clause 3 of Article 187 of the Constitution of India by the Governor of Nagaland in consultation with the Speaker of the Legislative Assembly. Rule 24 of the said rules provides for repeal and saving. It states that the rules of 1966 have been repealed by the said rules and that all the orders and the actions taken prior to the enforcement of the rules in respect of the matter for which there was no specific provisions in the rules shall be deemed to have been validly made or taken. Therefore, the services of the respondent number 3 came to be governed by the rules of 1999. Rule 10 of the rules of 1999 states that the qualifications for recruitment and promotions to any post or clause shall be as specified in the third schedule, although the schedule does not provide for categorization of the post under the Assembly Secretariat, but the post of ATO has been mentioned separately, and that is not a feeder post for promotion to any higher grade or post. Here is also a clear finding. As for the post of Assistant Superintendent, ATO, ARO, they are mentioned as the federal post for promotion to the post of Superintendent, Committee Officer, Research Officer in the third schedule, and further, the post of Superintendent, CORO, has been provided as the federal post for promotion to the post of Undersecretary. Therefore, there is a clear distinction drawn between the post occupied by the respondent number 3 and at the relevant time, that is ATO, and the other posts in the general category, such as ACO, ARO, or Assistant Superintendent. And then let me skip paragraph 26 and 27. My learned friend has already read, so why should I read again and again? 27 was read by my learned friend. If so advised, I can read, no problem. I have no problem in reading. I will read. To at least to satisfy my learned friend. This was his objection. The rules of 1999 came to be amended by notification dated 23/2/65, and it was known as the First Amendment. The First Amendment came into force with immediate effect from the date of its notification. It may, however, be noticed that the First Amendment was made in exercise of powers conferred by Rule 21 of the Rules of 1999 by the Speaker. Rule 21 is residuary powers conferred upon the Speaker of the Assembly. It provides that all matters where incidental and auxiliary to the provisions of the rules or otherwise shall be regulated in accordance with such orders as the Speaker from time to time make. From the language of the said provisions, what can be understood is that matters which are incidental or auxiliary to the provisions of the rules of 1999 can be regulated in accordance with the orders as the Speaker may make. The said provision otherwise does not confer powers upon the Speaker to amend the rules framed under Clause 3 of Article 187 of the Constitution of India. All that the provisions provides is residuary powers upon the Speaker. And paragraph 27 has been read by my learned friend, but my learned friends are still insisting to read, so I will read. It may further be seen that a second amendment to the rules of 1999 was effected with the publication of the notification dated 21/8/2012, and the same was made in exercise of powers conferred by Rule 22 of the Rules of 1999 upon the Speaker, which again is the residuary powers conferred upon the Speaker. With the insertion of the new rules at Rule 10 under the heading Streamlining of Existing Gather, the residuary powers of the Speaker, which was earlier provided under Rule 21, came to be shifted under Rule 22. Be that as it may, as already noticed herein above, the residuary powers conferred upon the Speaker by the rules of 1999 cannot be construed as the power to amend the principal rules, which otherwise has been framed in exercise of powers conferred by Clause 3 of Article 187 of the Constitution of India. Mr. Takamasa, Learned General Counsel for the respondent number 3, has also argued that First Amendment and Second Amendment of the Rules of 1999 cannot be sustained since the same was made in exercise of residuary powers conferred upon the Speaker. Although he has made that statement, they have never challenged. 28. The Learned General Counsel is correct in saying so, but the fact remains that even under the principal rules of 1999, a distinction has been drawn on the post of ATO, Vehicle Inspector, Senior Grade Drivers, which has no scope for promotion to the higher echelons of the service up to the rank of Secretary to the Legislative Assembly. Therefore, under the rules of 1999, the respondent number 3, having been appointed under the Transport Wing, cannot come under the General Wing. This is also a clear finding. Respondent number 3 cannot come to the General Wing. And if it is to be done contrary to this, either they should challenge the judgment or to do in accordance with law. Only two options they have. Although arguments have been made on behalf of the respondent number 3 that she, having been appointed under the erstwhile rules of 1966, she has the vested right to be considered for promotion to the higher post, such as the post of Additional Secretary, and that the rules of 1999 cannot take away her vested right. However, the fact remains that the erstwhile rules of 1966 has been repealed by the rules of 1999. The rules of 1999, as already stated herein above, has placed the post of ATO and the federal post of ATO separately, But under the third schedule, it also provides that the post of ATO is not a feeder post for promotion in the other higher grades. This is also relevant and important. The rules of 1999 has not been challenged by the respondent number 3, and therefore the claim for having her vested right to be promoted to higher post cannot be accepted and in fact misconceived. Very clear findings. Now, let me skip paragraph 29 because this is Article 187 and paragraph 31 also. May I read from paragraph 32? But let me skip the order portion. Paragraph 32. In the present case, the Immune Office Memorandum is not in respect of relaxation of rules or conditions of service of the rules, but a process of restructuring cadre by encathering the post from a particular schedule to another schedule. Further, such exercise has to be done in a just and equitable manner, which means that undue hardship should not be caused to other employees while relaxing certain provisions of the rules. As for Rule 22 of the Rules of 1999, as amended, it has already been held herein above that the residuary powers given to the Speaker does not include the powers to amend the rules, and therefore, invoking the said rules to restructure the cadres of the post under the Assembly Secretariat service cannot be sustained. To appreciate the contents of the office memorandum, so this is the memorandum which has been challenged.
Just
But here,
one second, sorry for interrupting, just 1 second. In view of this, paragraph 32, the first and second amendment of the Constitution, of the rules, 2005, 5 amendment and 2012 amendment, were found to be, was amended under the residuary power, so it was declared to be void application. Besides my restructuring, the first amendment of 2005 and second amendment of 2012 being issued by the Speaker under the residuary power, does not stand the test of law.
Only to relax the rules.
Yes.
Residuary power only to relax the
Yes,
rules.
only
so
to relax
So,
the
my lord,
rules.
the 2005 amendment and 2012 amendment does not exist in the eyes of law. That is the finding of the then single judge. The judgment has got both ways.
interpretation may vary from person to person, but what is the text and the direction and order passed by the Honorable Court, that is more important, Lordships. One very word is very vital. In a just and equitable manner. That means it cannot be just in favor of one individual. It has to be just in equitable manner. If hardship is caused to any of the employees, then that power can be exercised by the Speaker. Now, I have read paragraph 32, and I'm skipping this order portion. Paragraph 33. From the above abstract, it may also be seen that the upgraded post of Additional Secretary Transport held by the respondent number 3 has been restructured and encadred from the third schedule D to third schedule A general cadre. With such encadrement, the post of transport officer has been brought over to the third schedule A, and the same shall now be filled up by the subordinate officers in the next immediate lower rank enlisted under third schedule A by promotion through DBC. The office memorandum, however, does not specify as to what the next immediate lower rank to the post of transport officer is, and importantly, what would be the post for promotion for those who were placed below the post of transport officer under the third schedule D originally. Therefore, the Immune Office memorandum appears to have been issued in haste and without considering all these aspects. It also appears to be only an attempt to accommodate respondent number 3 for her promotion and recolorization as additional secretary in the general cadre to the exclusion of all others eligible to be considered. Very clear finding. There can be no confusion on this kind of a finding, Lordships. And let me skip it because this is the order. If it is relevant, I can write, no problem. Let me read 34. This is a citation of a judgment only. In the case of State of Manipur and others versus Suraj Kumar Okram and others, the FX court held that an unconstitutional law, be it either due to lack of legislative competence or in violation of fundamental rights guaranteed under Part 3 of the Constitution of India, is void ab initio. In the case of Shanti Sports Club and others versus Union of India and others, the FX court held that recording in the file is merely a noting some legislator and nothing more. It merely represents expression of opinion by the particular individual. By no stretch of imagination, such noting can be treated as a decision of the government, even if the competent authority records its opinion in the file on the merits of the matter under consideration. The same cannot be termed as a decision of the government unless it is sanctioned and acted upon by issuing an order in accordance with Article 77, Clause 1 and 2, or Article 166, 1 and 2. My learned friend is insisting to read this paragraph because of the fact that I have referred to some notings which I have applied through RTI, because in their affidavit, they have categorically mentioned that this enactment has been done in terms of the judgment and order passed on 12/5/2022. That was the categorical statement of the speaker. But this process was already approved on 10 May 2022, 2 days before the judgment. So my question was, okay, if you have done this pursuant to the judgment passed on 12 May 2022, how come then file was approved prior to judgment? So how can you say that this has been done in terms of the judgment? It's like putting the cart before the horse. No sense. A prudent man can easily understand. That is what I was making the submission and referring. But in their case, where the dishonorable court has made an observation in paragraph 34 of the judgment was, they tried to rely on some notings that it should be actually one cadre, he should get the promotional opinions. All these opinions, expressions were, some notings were placed at the time of hearing. I raised objection that, look, yes, there may be different opinions expressed in the file by different officers, but unless it is translated by converting to a valid order of the government, how can you just arrive to a conclusion that so-and-so at one point of time, his opinion was like that, his opinion was like that. This is merely a noting in the file, expression of opinion of different officers in the file. Therefore, on the basis of that, how can you claim a right? That is what I was making submission, and that has been reflected here by referring to the judgment. So our case under notings, and in that case, the notings was totally different. It cannot be mixed up and it cannot be confused, because there has been occasion where some confusion has been created and the orders have been passed. I pray that such things should not happen in future. Paragraph 35. Therefore, upon due consideration of the matter in its entirety and the findings arrived at the preceding paragraphs, it cannot be said that the rights of the respondent number 3 has crystallized in any manner, or that she has acquired a vested right under the rules of 1966 or the rules of 1999. Therefore, the case of Lik, Raj and others, Sapra, and the case of G. is Yadav Sapra are found to be not applicable to her case, and moreover, the facts and circumstances involved are also not similar. In the result, the Immune Office Memorandum dated 1/11/2021, Annexure D, and the Immune Notification dated 1/11/2021 are found to be unsustainable and are hereby set aside. May I pause here for a moment, Lordship? These two orders, 1/11/2021 and 1/11/2021, one notification and one memorandum. These are the two notifications. By one of the notifications, she was brought to the cadre, general cadre, and on the same day, by a notification, she was regularized in that. Therefore, that was challenged, and that has been quashed. And the very contentious issues start from the word however, because they are relying on this, on the ground that, look, this honorable court has given the power to do it, but in what manner it has to be done, it is clearly mentioned, Lordships. However, the same shall not debar the respondent authorities concerned from considering the restructuring of the various posts under the Assembly Secretariat, which should otherwise only be done. The word only is very important. Otherwise only be done in accordance with the relevant provisions of law and by taking into consideration of the rights and interests of all stakeholders. The sole issue in that case, that is WPC 323 of 2021, the whole issue in that case was encadrement and restructuring. And on that point, this Honorable Court has arrived to a categorical finding. And this finding, they have accepted. They have accepted. They have not challenged by both the respondents. Now, in the second line, the two directions which has been given, which can only be done in accordance with law. What can be treated as in accordance with law? For amending the rules, for restructuring, for gather review. Earlier, I was, of course, this will be a repetition, at the course of repetition, I'm making this submission. 1999 rules have been amended twice, once in 2005 and once in 2012. On both the occasions, gather review committee has been constituted and they have examined, they have submitted a report, thereafter only the rules have been amended. But in this particular case, taking advantage of the order, although not in accordance with the direction of the court, they have amended the rules within a period of 6 days. 6 days. And that too, the authorities have already constituted a gather review committee that was pending. There are 3 orders by which gather review committee to review and restructure the service rules have been appointed and that was pending. They were examining. They were directed to submit a report by end of April and June. When this was pending, amendment has been done within 6 days. Supersonic speed, unusual haste, of course, that amendment can be done only within a considerable period of time. Only this much that cannot be, but the unusual haste. Now, what about then the gather review committee, for which you have constituted the committee to examine for amendment of the service rule? We are not saying that you don't have the power. You have the power, but you exercise that power in accordance with law. And in accordance with law, to review the gather is by a committee. That is how they have done in the past. What prevented you to wait for the report of the gather review committee, where private respondent number 3 is one of the committee members? And another second observation is, which can only be done in accordance with law, provisions of law, and undue consideration of all the stakeholders. Then within 6 days, if at all they have taken into consideration of all the stakeholders, let them show from record what considerations they have taken. Our interest has never been taken into consideration. Yes, they may have taken into consideration of the interests of the private respondent, but not us, not the members of the association, lordships. Therefore, lordships, the rights and interests of the stakeholders have not been taken into consideration in terms of the judgment. Therefore, this amendment is nothing but to circumvent the order passed by the Honorable Court. Otherwise, if there is any confusion, if any clarification is required, they could have come before this Honorable Court. They have accepted the judgment, which has given a clear finding that respondent number 3 cannot come. A finding which this honorable court has laid down, they have tried to undo it. So they have done something which they cannot do directly. They have done it indirectly, which is not sustainable in the eye of law, Lordships. And now, Lordship, after the order has been passed, the notification by which private respondent was brought to the gather and regularized, that was challenged, that was set aside in question. Now, what would have been the consequences? Petitioners have approached this honorable court with a grievance, and that grievance has been done away with by this honorable court. Petitioners are yet to get the fruit of the litigation, even till today. Instead of considering his case for promotion, they have brought the private respondent and made to occupy the post, thereby depriving all the officers who are in the general cadre, who are due for promotion, who has a fundamental right to be considered for promotion. Right to promotion, not a fundamental right. I fairly admit that. But at least I have a right to be considered for promotion. I have been referring to the judgment of the full bench also, which has been passed, where the objection has been raised that what right do you have to go for promotion? But then court has said, they are in the same department, so they have every right to be considered for promotion. Now, Lordships, kindly come to page 78. This is the appointment of the one Dr. P.J. Anthony to the post of Secretary, Nagaland Legislative Assembly on 21st December 2019. And this was on deputation for a period of 5 months with effect from 2/1/2020 to 31/5/2020. It was appointed, not engaged. And during this time, there was no eligible officers who can hold the post of secretary. Therefore, none of the officers have been considered for promotion to the post of secretary, because eligibility criteria should be followed. And again, next page, page 79. This is the appointment with a condition to revert. His time of superannuation was approaching. May I read, Lordships? This is 27 May 2020. Consequent upon the completion of the deputation service of 5 months, the Speaker, Nagaland Legislative Assembly, is pleased to revert Dr. P.J. Anthony, Secretary, Deputationist, Nagaland Legislative Assembly, Secretariat, to his parent department with effect from 28/5/2020. Accordingly, he is relieved from the charge of the Secretary, Nagaland Legislative Assembly Secretary, with effect from 28/5/2020 for now, and his service are placed back at the disposal of the Lok Sabha Secretariat with effect from 28 May 2020. And thereafter, he has been reappointed, because this is for the purpose of making him retirement from the Lok Sabha, his parent department. Next page is page 80, Lordship. This is 6 June 2020. In the interest of public service, the Honorable Governor of Nagaland is in consultation with this Honorable Speaker. The Nagaland Legislative Assembly is pleased to reappoint. This is reappoint. Amended rule was, it was before the amended rules, reappoint Dr. P.J. Anthony, Secretary, retired, Nagaland Legislative Assembly, as Commissioner and Secretary on contract basis under the establishment of Nagaland Legislative Assembly Secretary for a period of 2 years with effect from 1/6/2020 to 31/5/2022 in the scale of so-and-so. The service of the incumbent will be automatically terminated with effect from 1/6/2022. This has the approval of the Cabinet, by Cabinet Memorandum dated so-and-so, dated 1st June 2020. Now, he retired from the Lok Sabha on 31st May 2020. on completion of 60 years. After completion of 60 years, under the service of the government of Nagaland Lordships, after 60 years, one is practically made to retire in all respect. Thereafter, if any appointment is done, then by way of engagement as appointment as advisors or consultant, not otherwise. So he has been appointed, reappointed, and after his appointment, first was his retirement with effect from 30th May, 31st May, and thereafter he was reappointed on contract. Yes, it is on contract, but he has discharged all the powers and functions of the HOD up to the retirement, which is not permissible under the Nagaland Retirement from Public Employment Act. Now, up to this, I'm skipping few pages, because there's a representation by the association. The issue and the grievance of the members of the association has been exposed by way of submitting a representation in the name of the association only. Now, come to kindly page 89. This office memorandum has been issued to follow the Retirement Act in letter and spirit to reinforce the existing law. Ban on extension, re-employment of government servants. This is issued on 15 March 2012. Attention of all concerned is invited to this Department's Office Memorandum number so-and-so, dated 26/2/2021, whereby government has banned extension of service or employment of government servants who have attained the age of superannuation on completion of 35 years in service or otherwise. It is hereby reiterated that no extension of service or employment of retired government employees as contract advisor or any level shall be resorted to by the departments without prior clearance of the PNR department, which will be considered only on exceptional and very special grounds. Any deviation from the laid down instructions will be viewed seriously by the government. So there is a standing order, and kindly come to page 95. Others are representations against his appointment, and he resigned. Dr. Anthony resigned on He resigned on 22/6/2022 with effect from 1/7/2022.
Who is that? Who is that?
His resignation order is not there, but he has resigned and then left. Now,
Resigned on?
he resigned on 22/6/2022, and then there in that resignation, he has mentioned that with effect from 1st July 2022. Although he has gone, role is still there, so we are still agreed. And rest are all representations. And kindly come to page 96, annexure L. This is a circular of 30th September 2020, issued by Dr. P.H. Anthony. His retirement from service was 31st May 2020. Thereafter, he was appointed. If it is appointed as an advisor or consultant, that is okay, anyway. But here, how he is exercising his powers as Commissioner and Secretary, like a full-fledged Commissioner and Secretary. A committee of officers of Nagaland Legislative Assembly Secretariat is hereby constituted with immediate effect to study and report to the Honorable Speaker on the following issue. Number one, to review the existing service conditions of the officers and staff of the Nagaland Legislative Assembly Secretariat. Number 2, to report on the anomalous stagnation, if any, experienced in promotional opportunities by the Nagaland Legislative Assembly Secretariat officers and staff. 3, to make recommendation for revision of the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rule 1999 as amended in 2012 of the NLAs. 4, any other matter within the review which the committee may deem necessary to study and report. And then committee members were appointed. And in the bottom of the order, Lordships will find, the committee shall present its report to the Honorable Speaker, Commissioner and Secretary on or before 28 February 2021. So this order was issued and it was pending during this time, during the relevant time. So this is the normal process, how the amendment should be done. For that purpose, I have enclosed this and relying on this document, Lordship. And this is a circular of 3rd October 2020. Here, by a subsequent order, all the constitution of the committees has been revoked during the pendency of the writ petition. That is just a ploy to defeat this petition. But here, this 3rd October 2020 has not been completely revoked. The substance of this order still remains. I will refer to the revocation order later, Lordships. A committee of officers of the Nagaland Legislative Assembly Secretariat is hereby constituted with immediate effect to study and report the Honorable Speaker on the following issues. To review the existing service, it is like the earlier one, Lordships. And then just last 2 paragraphs, which will be relevant. Report on point number 1, that is cadre review, and 2 above shall be presented by 31st January 2021. And thereafter, the exercise at point 3 above to revise the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rule 1999 as amended in 2012 may be taken up, and a report thereon shall be presented by 31st March 2021. And this was also issued by Dr. P.J. Anthony, Commissioner and Secretary, on 3rd October 2020. He is exercising full-fledged powers. And then next page, of course, that Lordship can refer to the type copy, page 99. This is 10 November 2020. In modification of this Secretariat Circular number so-and-so, Shri T. Nzambe Molota, Deputy Secretary, and Shri Leptin Chamir, Under Secretary, will also part of the committee constituted for reviewing the service rule and related matters of the Nagaland Legislative Assembly Secretariat as members. And then members are shown. This is for cadre review. And then next page, page 100. This is the office memorandum of 24th March 2022. May I read, Lucy? In continuation of this Secretary Circular number so-and-so, dated 30th September 2020, OM number so-and-so, 10 November 2020, Srimati Krohitono Rio. This is the private respondent. Additional Secretary and Shri Pakayandam, Under Secretary, NSSI President, will also be included as part of the cadre review, service rules, amendment committee. The authority has issued this order, and the president of the association has also been given. Accordingly, the constituted committee shall consist of the following officers, and then name of the officers are shown. And the last paragraph, the committee is further directed to complete all the mandated works as specified in detail under the circular referred to above, and including other periodical instructions given from time to time, possibly from 30th June 2022. This was also issued by Dr. P.J. Anthony, Commissioner and Secretary, on 24th March 2022. So this document shows that he is exercising the full-fledged, like any other normal government servant after retirement. So is it not contrary to the provisions of the Act of Retirement Act? And constitution of Cadre Review Committee is not a conditions of service, but it is a requirement in the service. Therefore, considering the need of the Cadre Review, the committee has been constituted to examine the restructuring of the cadres. Why not wait for this report and do it according to law? When all these orders are pending for submission of report, for completion of the report, the rule has been amended. That too, in defiance of the order passed by the Honorable Court on 12th May 2022. Therefore, the entire exercise for Cadre Review Committee has been made redundant also by doing this. That is the reason why we are saying that this is not in accordance with law. Now, all the Cadre Review orders have been again revoked on 27 June 2022. That is during the pendency of this writ petition. See how meticulous the respondents are acting.
It was revoked on?
Yes, revoked on 27/6/2022.
On 27?
I will try to find and then I will furnish a copy of that
You
also.
just give the date?
I had. Date is 27/6/2022.
Okay.
Revoke all the,
Page
But-
19 of the government, I've never responded number one, but you can see, page 19, annex 3. That's a simple law.
but 3rd October 2020 at Annexure M,
Of?
writ petition, page 97, Annexure M. This is an ordered circular dated 3rd October 2020. This has not been completely revoked by the revocation order dated 27/6/2022. This has a relation with one of the orders, but this entire circular has not been revoked. Only partially it was revoked.
We will continue tomorrow.
Yes, I'm finishing, Lordship, please.
Same order like yesterday. Just list the matter, first. Tomorrow.
Obliged.
Extrapolate, okay? What case is still going? No.
For admission, item number 3.
Lordship, it's a consensus prayer that this matter may be listed next week.
Okay.
Yes, tomorrow it may not reach also.
On request made by the parties, list the matter after 1 week.
Lordship. Much better.
Perhaps, Lordship.
Yes, please.
Lordship, I beg to mention item number 6 and 7. Here I'm yet to file my power as well as affidavit in opposition.
Oh,
6 and 7. I'm for the respondent 1 in 6 and in item 7, I'm for respondent 14.
okay.
Can you give me 3 weeks' time, Lordship?
Lordship, in that case, I pray that the matter may be fixed on 23rd of March.
Okay.
Yes.
On request made by Mr. Paseco, learned counsel for the respondent number 1 in Civil Revision 4 of 2022. List the matter on 23rd of
March.
March.
Yes, Your Lordship. Lordship, for me, I'm proposing on 23rd of February, but the opposite party, they say they could not make it on that day.
Lordship, I was suggesting second week of March, but however, since the
AG will
AG
be
will
appearing
not be
in this
appearing.
matter, so Lordship on
Okay,
23rd.
23rd March.
Bless my Lord.
Lordship,
Lordship, I also beg to mention item number 3. Lordship, here I'm for respondent 4. Lordship, I may be allowed to file an additional affidavit, Lordship.
Additional counter.
Additional affidavit, Lordship. I filed my counter, but I need to make a clarification in my affidavit, so I may be allowed to.
Joshua?
In fact, Lordship, respectfully, there would be no necessity, as per my understanding, to file another
He
affidavit.
wants to
But
file an additional affidavit, so if you...
anyhow, Lordship,
Okay, heard Joshua Shiki, learned counsel for petitioner. On request made by Paseco, learned counsel for the respondent number 4. How much time?
Lordship, 3 weeks, Lordship.
3 weeks' time is allowed to file additional affidavit. List after 3 weeks.
oblige you, Lordship.
Bless my Lord.
Lordship, I beg to mention item number 8, Lordship. Lordship, in this case, the state has filed affidavit in opposition, Lordship. If I may be allowed 3 weeks' time to file reply, Lordship.
Mr. Majamil, learned counsel for petitioner is allowed 3 weeks' time to file reply to the counter filed by the state respondents. List after 3 weeks.
Much obliged, Lordship.
May I please, my lord?
Yes.
I beg to mention item number 5.
Ah.
My lord, I'll be filing my affidavit in reply, so kindly allow me 2 weeks' time.
You are MS Any.
Yes, lordship.
MS Any Terry, learned counsel for petitioner is allowed 2 weeks' time to file reply to the counter filed by the state respondents.
Yes, your lordship.
List after 2 weeks.
Perhaps, Lordship. Lordship, item number, I may be allowed to mention item number 2 on behalf of Mr. Gauhati. He's for respondents, Lordship. Can you let it come after 2 weeks, Lordship?
On request made on behalf of Mr. Yamawati.
Number 2.
CGC. List the matter after 2 weeks.
2 weeks, Lordship. Bless my Lord.
May I please, Your Lordship? Lordship, I seek the indulgence of this honorable court, my lord, to upgrade item number 9 if possible. Lordship.
Have you taken the consent from your colleagues?
Yes, yes.
May it please your Lordship. In fact, Lordship, the item
Is it
number
a
1.
yes? Is it a yes or no? Just-
No, if my lord wants to listen, the elaborate submissions and all, Lordship, it may take about 2 days to complete the argument. So if my learned senior colleague, since he has requested, perhaps we can list our matter after the elections.
This item 1?
Yes, Lordship.
Okay, on request made by Joshua Shiki. Learned counsel for the petitioner. List the matter on 13th March.
My lord.
13th March.
Oblige you, Lordship.
Lordship, item number 4, that is a short matter only, because today we are supposed to submit a statement that advice from the AG, which could not be done today. So I need a little more time. I've taken the consent.
Yes.
No objection, Your Worship.
EMS,
SK Achumi.
heard MS Kajun, learned counsel for petitioner.
3 weeks time,
Request
Lordship.
made by Mr. Kekamuli, learned counsel for respond number
All the
for
respondents.
the respondents. List the matter after
3 weeks, Lordship.
3 weeks. Yeah.
Much obliged.
Oblige you.
Maybe if you worship, my lord. Item number 2, my lord, my learned friend has mentioned. They have taken time, my lord. Kindly, if I may allow to pray, kindly that may be fixed on any date.
What did I say?
First week of the March, my lord. March.
First week of March.
Yes,
Item
my
number
lord.
2,
Any
Lordship.
date, my lord.
Okay, 2nd March. 2nd March.
Item
I'm
number 2.
obliged, my lord.
Item 3. Item 2.
Item 2.
2.
Obliged, my lord.
Obliged, my lord.
For admission, item number 9.
Lordship, if your Lordship permits, I would like to impress upon your Lordship that even the prayer number 1, even that is illegal.
Okay. In the writ petition.
That's it. Now, Lordship, at page 33, my lord, page 33
Of the writ petition.
of the writ petition, my lord. And
1 minute. Okay. Yes.
Lordship, resolution number 4, my lord. Now, Lordship, yesterday, a submission has been forwarded by the Learned Council saying that this Shilumong, my lord, is nothing but blessing. Nothing but blessing. So, therefore, this inner cause is harmless. Now, my lord, whether Shilumong, your Lordship knows, Shilu, we have no problem, my lord. That is a reiteration once again. But Mong, my lord, can have different connotation, my lord. It may connote different meanings. It may be blessing, it may be privilege. Lordship, I was going through the our dictionary by the Aussenton. If I may just refer to
So we'll construe it as a blessing.
Lordship, if it's Lordship, no. What I'm submitting is, my lord, my respectful submission is, what did they mean? What did the respondents mean? That matters, my lord. Because their conduct, my lord, they cannot take a stand contrary to their conduct. What they intended. Lordship, if we see the development after this and the decisions that passed by them, their intention and what they meant is very clear. It's absolutely clear, Lordship. They did not mean blessing. They meant support.
Okay.
Therefore, if it's intended to be a supporting that only one candidate, then it's absolutely illegal, Lordship. Therefore, what is the meaning of Shilumong, that Mong, my lord? They say it's just blessing, but my lord, this blessing was given in 2019, initially, and it's reiterated. And my lord, based on this blessing, all others candidates have been barred from contesting. That's on this blessing. And all the villagers have been told to vote for these people. They cannot even go against this decision, this Shilumong, which has been taken on 28 December 2021. Therefore, my lord, it's not just blessing. Absolutely illegal. It is an intention to support the particular person, and no person should even speak or do anything against this decision.
Mr. MT,
Yes.
I've got what you're trying what you're trying to
Yes.
Now let us hear what City says about Shilomon. If he says it's a blessing,
It's a blessing. Yes, my lord.
this court will construe it as a blessing, directing the citizens of this
Muslim in the
particular village
village.
that to consider this as a blessing, and because of this Shilomon, no other persons can be debarred or
Or the voters threatened also. my lord.
or threatened to vote against any particular person or to contest in the election.
Yes. Because, my lord, just 1 minute, my lord.
Anyway, that
Even-
is what I'm thinking.
Yes. Last night also, based on this, there were trouble in the village, seems.
What is it?
There was some kind of, Lordship, some kind of people were gathering and all that kind of thing. Intimidation in a way, my lord. So this kind of, this will set a bad precedent, my lord. It will give it's a disguise. It's support for a particular candidate in disguise, my lord. It may set a bad precedent, especially in our areas, my lord. Because, my lord, Lordship, may kindly come to page 35. 35, my lord. I have translated in English also. And my lord, before I do that, my lord, if I may, my lord, Lordship, may kindly look at the affidavit also. Affidavit
Of the respondent.
of the respondent number 5, my lord. And the annexure. Annexure at page 12, my lord. Annexure at, yes, annexure 1 at page 11. My lord, look at the translated copy at page 12. Of course, this is a translation which was done by the petitioner and has been accepted and used by the respondent. Now, my lord, number 4, the citizens of Monsignity endorse the proclamation of Rion Sanga Putu, Monsignity to bestow the privilege and responsibility of contesting the forthcoming Nagaland states. So they have also accepted this translation.
Is this your translation in the writ petition?
Yes, my lord.
Let us.
Lordship at page 34. But Lordship knows the language, so Lordship can. This is we tried our best to interpret it as far as possible.
See, at the end it says,
Yes, Lordship.
Nagaland Legislative Assembly election long tuk sukrut akajang since sangar to me muatzer.
Muatzer. Now, Lordship.
Here that muatzer is not properly translated.
Okay, Lordship. Now, Lordship. Now, what was the intention? Lordship, may kindly come to page 30. We'll read the our one, my lord. That is better. At page 35.
35.
35 of the writ petition.
Yeah.
Lordship, let me read everything, my lord. Timim since utajong tamasa ryong sangar putu mandani ti ajanga asen since utajong ajak tangi Isus timim salam nam sadaber aser tamalan subject nung shia liba nung amantagar asen since ajak ajong aser tumaze anguzin nakla nung ryong sangar putu ikin tepensa 9 July 2019 nung tata salang nung sindaban tan ningi si tongbang uzagam minister koba political party nung litie yang ji yong sangar putu a aliza ta lamdata arwa 28 December 2021 no sinsu mungdang nung putu lamdat akaza dang sinsu aja gi taka manganga iba putu lamdat akiza a sinsu shilumong akaza ta lamdata ayuba tali tashi Xia talita xia auzi nakshitong yor iba lamdat putui kan rebang xia yamai suzu ajak tangi sangdong yoker 28 December 2021 anoko nung monsonim season su mundang nung yung sangar putui sri tongbang uzagam kuba political party nung litir yang ji yung sangar putu alizeta usang sinsu mundangi nung mundang ti nung akazedang sinsu mundangi a taka manganga akizaka ya shilumang akazir da lamdat anong ji ipa lamdat nung ajimdakar muslimi yung sangar putum ajanga sinsu ajak tang yamai sangopsir 2023 Nagaland State Assembly election nung 24th angat yung bang assembly constitution nung asin sinsu maung akaziba tak alaga asin sinsu shinga kasa constitution nung election nung motuktop sa asa iba sinsu lamdat anama shingaya inyaka masira chimbia masinuz ta sinsu sangar ajak tashi nung putui namshia mada taksa iba nung ay balanerkar atokra putui ngurkilang chawka pa la maba alang nansha ta sinsu ajak nam mada taksa see lordship now very clear my lord shilumo because this is very clear lordship absolutely based on this Absolutely illegal, my lord. If this is allowed, my lord, every now and then, every election, they say Shilumang and finish. Lordship.
What are they saying in the affidavit?
They're saying it's just a blessing, but Lordship, there's even the Putu Mundan, which is a statutory body recognized by the Village Council Act under Section 6 seconds proviso, even supporting a political party, my lord, a particular candidate.
Yes.
Lordship. Therefore, my lord, we have to interpret the word in the context it was used, and also by the conduct of the parties, my lord, we can very well ascertain what does it mean, what they intended, my lord. Intention is to support only one particular candidate, the particular person chosen by the Putu Mundan, my lord. And then, my lord, can they take a stand which is contrary to their conduct? Of course not, my lord. Lordship is very well aware the law is settled. Then, my lord, again, it is very clear that it's a support. Here, Shilumong, the Mong word, Mong will mean, my lord, privilege. Privilege is given to this fellow, this person, particular person. The support is given to this person. It is not just blessing, my lord. It's not just blessing. Biasness, my lord. Favoritism in favor of one particular person. Absolutely illegal. Therefore, my lord, even this has to go. If this is allowed to stand, my lord, there will not be a free and fair election in the village. Absolutely not. And also, my lord, it will set a very bad precedent, especially in our areas.
Yes.
My lord, and one more thing. A thing which just cannot be done directly, cannot be allowed to be done indirectly. This is what exactly they're trying to do, my lord. Therefore, my lord, my respectful submission, my lord, I plead before your honorable court that this is absolutely illegal. And this will not only harm the petitioner, my lord, but even the persons who wants to support him. And also, my lord, in the future. It's a very bad precedence, my lord, dangerous precedence, my lord.
At the outset, Lordship, yesterday I have considered to the other prayers, out of the many prayers, except the first prayer. And I wish not to argue on other points with regard to the maintainability, the course of action, misjoinder of parties, premature writ, considering the entire pleadings in the writ petition. The writ petition is premature, but I'm not arguing on all these things. Keeping in view of the resolution which was taken on 28/12/2021, I would like to refer to only 3 paragraphs of my affidavit. Thereafter, I leave it to your lordship what decision can be taken. So I would like to refer to paragraph 5 of affidavit in opposition, warrant on behalf of respondent number 5. Only 3 paragraphs I will read, lordship. Has the lordship got it?
Yes.
May I read? That the respondent denies the statements made in paragraph 4 and 5 and humbly picks to state that the action of the respondent number 5 to bestow a renewed blessing. This is the correct interpretation of Shilumang. Renewed blessing to Shri Tungbang Uzakam during 61st Senso Mongtang General Citizens Meeting held on 28/12/2021 was on the basis of an open invitation from the respondent number 5 to all the citizens of the village to bestow blessings to the intending candidates. Anybody who came forward would have been placed, but no other person came forward to avail such blessings except Shri Tungbang Ozakam. The general meeting of the respondent number 5 is held once in every 3 years, and the said general meeting of respondent number 5 was the only meeting before the election scheduled to be held in the month of February, March 2023. Therefore, blessings were bestowed to him by the citizens attending the general meeting. It was always open for the petitioner to come forward and seek such blessings, but the petitioner never availed the opportunity, and as such, the petitioner cannot allege that bestowing of blessings is illegal in the eye of law, and as such, the petitioner cannot claim the blessings given to Shri Tungbang Ozakam as a matter of right before this honorable court. The petitioner himself was present in the meeting while bestowing the blessings, and during that time, he had no objection. The petitioner was also a party to such decision, and therefore, the petitioner is stopped to question on such decision, where he was also a party to such decision. Further, the respondent number 5 has not committed any illegality, and the petitioner has miserably failed to show any records in support of his allegations, and as such, the petition is liable to be dismissed. Now, if the petition, considering the contention taken by the petitioner, then if it is to be decided who has given the blessing, how, in what manner, how to decide that? We are required to take evidence, and this is a decision by the Monsiemdi Sunso Mungtang, respondent number 5, in a General Assembly meeting. And the persons, if the petitioner is agreed by bestowing blessings to a particular person, then, and he is agreed by that, then all those persons who has given the blessing, bestowed the blessings to a particular person, and if he is agreed by that, then all those persons should be made as party respondent. Number 1. Secondly, if bestowing the blessing to a particular person is held to be illegal, then the proper way of bestowing the blessing to somebody else, XYZ for that matter, can this honorable court, in exercise of under Article 226 of the Constitution of India, can issue a direction that no, the blessings bestowed to so-and-so is not correct, proper, it should not have been given, it should have been given to Mr. XYZ or ABCD. Can such a direction can be issued? And that is what the petitioner is insisting before this honorable court, lordship. Therefore, what constitutional or fundamental rights of the petitioners have been violated by bestowing the blessing, by bestowing renewed blessing, Shulomon. No right has been taken. That is why, and whatever orders have been passed, which my learned friend has also referred to, those orders, yes. Frankly, fairly, we are considering that, look, if any order or decision which is adversely affecting the rights of the citizens, for that matter, the fundamental rights of any citizens is violated, we cannot defend such an order. Therefore, this honorable court can question. But what is wrong with bestowing the renewed blessing? That is the issue here, lordship. And I would like to refer to another 2 paragraphs, paragraph 10 and 11. Paragraphs are short, lordship. Paragraph 10, page 6, that the deponent denies the statements made in paragraph 11 and 12 of the petition and humbly begs to state that the respondent number 5 was never barred any person from contesting the election, but the petitioner's intention was to tarnish the image of the respondents to serve his personal interest. The respondent number 5, by bestowing renewed blessing, has not violated any statutory or constitutional provisions so as to invoke the writ jurisdiction by this honorable court, and as such, the petition is liable to be dismissed. Paragraph 11, that the deponent denies the statements made in paragraph 13, 14, 15, 16, 17, 18, and 19, and humbly begs to state that the allegations against the respondent number 5 for expulsion and excommunication of the petitioner is incorrect and cannot be attributed to respondent number 5. It is also stated that bestowing of renewed blessing to any individual cannot be treated as against any public policy. Rather, bestowing renewed blessing on any individual is a good gesture and good public policy. See? Had the petitioner came forward in the meeting on 28/12/2021, he would have been given the similar blessing. However, he remained silent. Thus, the petitioner is making false allegation against the respondent number 5, which is misleading. So, if bestowing renewed blessing is to be treated as a violation of his right, then how to decide this? Obviously, by adducing evidence, and he has to implicate the parties who has bestowed the blessings, and they are not the parties before this honorable court. Now, another defect which my learned friend has made in the prayer portion. Writ petition, the prayer portion, page 27. The first prayer, quashed and set aside. The decision, resolution number 4, which my learned friend has already referred to, taken by respondent number 4. This is not correct, Lordship. So if all we are to go by the pleadings and the prayer of the writ petitioner, then yes, if there is any decision by respondent number 4, let that be quashed. But so far as the resolution number 4 is concerned, which was decided on 28/12/2021, it is the decision taken by respondent number 5, not the respondent number 4. And there is no resolution of respondent number 4. Resolution number 4 taken by respondent number 4.
Yes, that part is correct.
Lordship, Lordship, insofar as measures has not finished.
No, practically that is all, except this one
Prayer
part,
portion.
prayer portion.
Prayer portion, my lord. This decision was taken earlier by the respondent number 4.
That I don't know.
No, my lord, they mention it. They say it. Page 35 itself. That is, paragraph 5 is contrary to page 35, annexure 4, my lord. Because they said the decision was taken there. It was taken here, my lord. It was taken earlier by the respondent number 4 on 9th July 2019. They themselves say it, my lord, and subsequently endorsed by raising hands in the meeting held on 28/12/2021. A decision to support one political party was already taken by the Putumundan in the year on 19th July 2019. And that was,
Where are you reading from?
my lord, page 35, my lord, Tamasa 1-2. My lord, the beginning.
No, that's fine.
Lordship.
Page 33.
Lordship.
This is a decision of the Sunsumungta.
This is a decision of the Sunsumungta, yes. Yes. Insofar as that is concerned, my lord.
So that your prayer number 1.
Yes, my lord.
This is
Resolution number 4.
Some mistake is there.
Yes, resolution number 4. Not respondent number 4, should be respondent number 5, my lord. This resolution number 4 was taken in the meeting.
It's up to you. If there's no objection, we can correct it. Otherwise,
Lordship, this is.
you will have to file an amendment.
This is, Lordship, this is. It is there, my lord. It's there on the record, my lord. It's just there on the record. It's just an error.
It's up to city. If he has any objections.
My lord, this is a fact, my lord. This is there on the record. It's just there on the record.
Anyway, cool. Oh, okay. I'll dictate in the chamber.
Lordship, no judgment is required. Otherwise, the Khar
Not
village.
required, not required. I'm allowing the petition.
Oh, much obliged, my lord. Much obliged. Obliged, my lord.
IA also goes.
But, my lord, with regard to the resolution.
Resolution also, there's already an implication in page 35. It implies that Shillomong is not properly given.
Page 35?
Yes. Of the Putumundan. They've translated it into a different aspect. Anyway.
Lordship, this is the decision taken by Putumundan. not by the Sun Sumungtang. Sun Sumungtang has only given a blessing, not the decision to debar him from contesting the election, not to enter the village.
why I'm
All
saying-
these
that's
decisions
why
are
I'm
taken by
saying-
the village council.
That's why I'm saying the Putu Mantan has taken a wrong view of the decision of the Sun Sumungtang. That part I'm going to make it clear.
That part
That part I'm going
we
to
have
make
already
it,
considered.
I'm going to make it very clear that the Shiloh Mound will be construed only as a blessing.
Yes.
It is construed only as a blessing. That's why I'm allowing the writ petition in the sense, I think you have misunderstood me. That the first resolution of the Sun Sumungtang need not be interfered, but I'll make it very clear
Lordship.
that this is only a blessing and this cannot have any repercussion on any persons or any intending candidates who wants to contest the election.
Lordship. Yes.
That part.
Lordship.
I'll dictate in the chamber. No,
Much obliged, ma'am.
I'm setting aside all except one.
Lordship, but
That one part, I'm going to make it clear.
Lordship,
And I'll direct the Deputy Commissioner, Mokcho, to ensure that there's free and fair election in all constituencies in Mokchung district, particularly 24th Angantupa constituency.
Lordship, Deputy Commissioner has already issued a
even then.
general circular.
That part
That is in the common affidavit.
Yeah, that
They
I've
have been
seen,
closed.
that I've seen. Government is represented by?
I have completed in paragraph 25 and 29 of the writ petition. I have explained. It is in the report.
Your government affidavit is there?
It's there.
Paragraph 25 and 29.
29.
You need not worry.
Lordship,
Your thing will be protected.
Lordship, obliged, ma'am. Obliged.
All the parties can go back happy.
Yes, ma'am. Obliged, ma'am.